Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LL.M program, in which Catholic University has cooperated with Jagiellonian University in Kraków, Poland for many years. I will be your moderator. Louise Leiden, the Executive Director of Development and Alumni Relations for the Columbus School of Law of the Catholic University of America, will bring greetings from our law school.
Thank you, Professor Wortham. It is a pleasure to be here with all of you. I want to thank Professor Wortham for her leadership from our end in putting this particular program together and recognize her efforts to foster and cultivate the relationship with the best law school in Poland at Jagiellonian University. It's an honor to work with someone so knowledgeable about the law, but who's also a genuine friendly people person. She's built on the deep roots established by the founder of the Catholic Jagiellonian relationship, Emeritus Professor Rhett Ludakowski, who many of you know. Catholic law values this 30-year relationship with Jagiellonian University. The International Business and Trade Summer Law Program, American Law Program, and LL.M in American Law now have more than 2,000 US, Polish, and other international alumni. And I welcome all of you here today.
Thank you very much. I now turn to Wojciech Bańczyk, who is coordinator of the American Law School, and he will welcome you on behalf of Jagiellonian University.
Thank you very much, Professor Wortham, for this nice introduction. Dear participants of the series of webinars, it's a great pleasure to express, on behalf of the Jagiellonian University, the great joy that you all joined us in the online meeting, showing your interest in the contemporary challenges in American and global law. Also, this position allows me to present the gratitude to all persons without whom it will never be possible for this event to happen. It's a source of great pride for the Jagiellonian University to co-organize such an interesting event. The event, which for months keeps gathering a huge audience, as nearly or over 200 per event, but also being yet another event which gathers the cooperation between Jagiellonian University and the Catholic University of America, which continues despite the difficult pandemic situation. Given the current troubles, the traditional way in which joint programs such as the American Law Program, the LL.M program, or the Summer Law School used to be held, we decided to develop a new initiative to stay in touch with those with whom we've spent so much nice time, but also with the people who just newly became interested in our offers. That's why we decided to develop a new initiative, so that in the absence of traditional insight meetings, we could offer a new way to learn and to meet together. At the same time, we do hope that sooner or later, we'll meet in person during our programs or alumni events.
Thank you. So we're delighted to have so many of you with us, even as we begin the busy holiday season. The information on the winter series for January through March will be on the website very shortly. And those of you who are alumni will be getting email invitations in your email as well, but you can always go to the website and register for events and see what's coming up. That series brings a really fascinating array of topics, including the differing approaches that the Biden administration is likely to take on international law issues, how well the post-2008 financial crisis infrastructure may hold up to the pandemic's challenges, parallels in the process, politics, and policy of the European Union and United States budget making in a COVID-challenged world, the application of COVID to force majeure contracts in commercial contracts, and the European Union's new regulation on sustainability-related disclosures, the reach of which will reach across the Atlantic and perhaps have a similar impact to that of the EU General Data Protection Regulation. So something that American lawyers need to learn something about. The holidays are a good time to think back over memories of classmates and other friends, even more so in our lockdown world. We urge you to reach out to classmates and colleagues about the possibility to connect through these webinars. Maybe you should organize your own post-webinar discussion group of some of the issues. As the 6 webinars in the fall season close, I am going to quickly acknowledge the team that Wojciech just mentioned, because it has taken a real village to put this out. That begins with the strong support of Dean Stephen Payne of Catholic University and Dean Jerzy Piszuliński of the Faculty of Law and Administration of Jagiellonian University. We thank Professor Piotr Szwedo, who is director of the Jagiellonian Foreign Law School Center, commonly known by its Polish acronym as OXPO. He's also faculty director of the American Law Program and the Jagiellonian director of the International Business and Trade Summer Law Program. Thanks to Wojciech Banczyk himself, who welcomed you and has made a tremendous amount to make this series happen, as he does for the live program every year. Juliana Kobierzyńska, who is the International Relations Specialist at the Foreign Law School Center, has been at OXPO since its founding, now more than 20 years ago. Special thanks to Lena Helinska, who designed the beautiful and functional and informative website for the webinar series and for OXPO. So the URL for the series is in the chat to remind you where you can find it. Here at Catholic University, many thanks to Louise Leiden, our law school's Executive Director of Development and Alumni Relations, who already welcomed you. Kate Smith, our Alumni Director. Christina D'Amelio Lopez, our Director of Advancement. Jean Emery, who is the Office Manager from the office and handles all things data and many other things. Pash Madwani from the University Development Office, who provides the tech infrastructure that makes this all possible. Also thanks to the law school's Marketing and Communications Director, Joe Ferraro, and his staff, Al Washington and Jillian Salazzo. All those people work hard on this series. So many, many thanks to them as we close out these first 6 webinars. Also, last but not least, our LL.M coordinators and LL.M graduates, Gaspar Cote and Luke Bartosik. So as we turn to today's program by Professor Megan LaBelle on artificial intelligence and intellectual property, with comments by International Business and Trade Summer Law Program alumnus Tytus Cytowski. Megan, if you want to go ahead and put your screen share up of your slides, you can get that up while I explain a little bit about how the webinar is organized and also introduce you and teachers. I expect most of you have used Zoom before or a similar video conferencing platform, so you know about typing questions in the chat. I'll be taking questions from the chat and posing them to our speakers. In addition to the chat button, you can see a participants button. If you click there, you can see the names of the people who are signed on. If you go to the gallery view button on your screen, likely at the top for most of you, you can see the screens of those who are signed in, or you can see them on a panel on the side in speaker view. And those have identifiers. In addition to the interesting webinar and question and answer that will follow, you can use the participant list, the screens, and the screen names to replicate at least a little bit of the networking a live event would provide. If you see a friend to whom you'd like to send a greeting, you can send a private email in chat by hitting the drop down and switching from everyone to that person's name. So you might want to glance periodically at chat and see if someone has sent you a message, as well as seeing questions that have been posed and information that's been posted. So unfortunately, the registration software does not recognize some Polish characters. So we apologize if some letters in your name show up with a question mark. To avoid that, when you register in the future, just use English characters as the closest you can. So Professor LaBelle will speak for about 20 minutes. She'll be followed by a comment from Mr. Cytowski, who will lead off the question and answer period. As I mentioned before, please type your questions in chat as you think of them. After Professor LaBelle answers Mr. Cytowski's question, I will pose questions from the chat to either or both of the speakers. The session is being recorded, and the 60-minute webinar will be posted on CUA's YouTube channel within a few days. The series website also links to those recordings. At the end of 60 minutes, I'll close the formal webinar and the recording will cease. Professor LaBelle and Mr. Cytowski have graciously agreed to stay on for up to 30 minutes more so they can answer more of your questions. And I encourage any of you who would like to stay on for more questions and discussion. So in the chat, you'll now see links to the bios for Professor LaBelle and Mr. Cytowski. And I'm now going to mention a few highlights from those bios. Megan LaBelle is Professor of Law and co-director of the Law and Technology Institute at our law school. Professor LaBelle teaches and writes about intellectual property, civil procedure, federal courts, and administrative law. Prior to joining the faculty, Professor Belle focused on intellectual property and complex civil litigation matters with the prestigious Los Angeles firm of Munger, Tallis, and Olson. Her scholarship engages in patent law as well as civil procedure and administrative law. Professor Belle was Senior Notes and Comments Editor for the University of California at Davis Law Review and was a law clerk for the Honorable Stephen S. Trott of the Ninth Circuit U.S. Court of Appeals and the Honorable Margaret M. Mauro of the U.S. District Court for the Central District of California. Mr. Cytowski founded Cytowski and Partners in 2009 after working for a venture capital fund and as a financial services lawyer for the Deckert firm. Cytowski and Partners is a technology, new media, and business law firm concentrating on technology, startups, and venture capital. Based in New York with offices in Silicon Valley and Warsaw, the firm works with entrepreneurs, emerging companies, angels, and investors in the US and Europe, helping businesses interested in working particularly in the Central European market and entrepreneurs interested in seeking investment capital from the US. Mr. Cytowski has a magister degree from Warsaw University and participated in the CUA, JU, IBTSLP in 2001. He received an LL.M. from Harvard Law School in 2005. So we now turn to Professor Belle. Please remember to type your questions in the chat, and her remarks will be followed by Mr. Cytowski's comment and lead off with questions.
Hey, good afternoon, everyone, or maybe good evening or good morning, depending on where you are in the world. I'd like to start off by thanking Professor Wortham and everyone else who is involved in organizing this webinar series and for giving me the opportunity to participate. As Professor Wortham mentioned, I have taught in both the American law and the summer programs in Krakow and have had such a great experience, and I'm a big supporter and fan of the work that the Jagiellonian and Catholic universities have done together for so many years. So I really appreciate this opportunity to participate today. Okay, so as you know, my topic today is artificial intelligence and intellectual property, and that is a really broad topic. So, and we have limited time in our webinar, and so my plan for today is to focus on US policy on AI and IP. We use lots of abbreviations in IP, so that's appropriate here. So in terms of policy, I wanted to start by talking about policymakers and just mention that in the US, there isn't one single agency that focuses on innovation and intellectual policy. There are a number of agencies, including, but certainly not limited to, the Copyright Office, the IP Office of the State Department, the International Trade Commission, the Federal Trade Commission, the White House Office of Science and Technology, and then of course, the US Patent and Trademark Office, or the PTO. So here it seems that the PTO is taking the lead on AI and IP policy in the US, not just with respect to patents and trademarks, with respect to intellectual property. And so I'm going to be focusing on what the work that the Patent and Trademark Office is doing in this area. So back almost 2 years ago now, in January of 2019, the PTO held one of the first conferences in the US on artificial intelligence and intellectual property. And though I've included a link here to the proceedings of those events, if anyone's interested in watching them. And based on that conference, the PTO has done substantial follow-up work over the past almost 2 years. So in the fall of 2019, the PTO followed up that conference by issuing 2 requests for comments on artificial intelligence and intellectual property. And what I mean by that is the PTO asked stakeholders to provide input, thoughts, comments, etc., on various questions about artificial intelligence and the intellectual property, various intellectual property regimes. So the first request focused on patents and the second focused on other IP, so copyrights, trademarks, and trade secrets. And there were a lot of responses received, over 200 responses from a host of different stakeholders, including companies, individuals, academics, trade associations, public interest organizations who wanted to share their thoughts and their input on sort of where we're at with artificial intelligence and IP. And so the PTO gathered all that information, all those comments, and just in the past couple of months, in October of 2020, published an extensive report on artificial intelligence and IP titled Public Views on Artificial Intelligence and Intellectual Property Policy, which is, again, what most of my talk will be focused on today in highlighting some of the key findings from that report. Okay, so before we talk about how we protect AI from an IP standpoint, the starting point, I think, is what is AI? That certainly was the PTO's starting point in asking questions of stakeholders. And artificial intelligence has been defined in different ways. One proposed definition by IBM and others is that AI can be understood as computer functionality that mimics cognitive functions associated with the human mind, for example, the ability to learn. Others say we shouldn't try to define AI. AI is dynamic. As soon as you give it a definition, it's going to change. So what's the point? So that's our starting point, right? What is AI? And then, excuse me, when we talk about AI inventions, what do we mean by that, right? That term can be defined very broadly, and there wasn't really consensus on this. Some commenters, again, said we shouldn't try to define AI inventions. Others said, well, AI inventions can include, but shouldn't be limited to, inventions that embody an advance in the field of AI, inventions that apply AI, but apply it to another field, or inventions that are produced by AI itself. So one thing that there did seem to be some consensus on is where we're at with AI. So there appears to be consensus in the US that right now, the current state of the art with respect to AI is narrow, meaning we have AI systems that perform discrete individual tasks in well-defined domains. And what we don't have yet is what's known as artificial general intelligence. In other words, we're not quite at the point where we have AI systems that actually think like a human and that can think on their own. And a theme of the PTO's report that can be, I think, a theme that we can take away from the PTO's report is we may have to revisit a lot of these questions I'll be talking about when and if that ever happens, right? If we have AI systems that actually can think like a human being. But the consensus seems to be that right now, we're not there yet, and that AI systems still require substantial human intervention. Okay, so again, in our limited time, I can't summarize this entire report and all the findings. So I wanted to highlight a few of the sort of big themes in the report, and I'd say focus on some of the biggest issues that I see confronting AI and intellectual property in the US right now. So one big question is related to both patent law and copyright law. With respect to AI is, who can be an inventor? And then on the copyright side, on the second slide, I'll address this, who can be a creator. So under US law, an inventor is defined as the individual, or if a joint invention, the individuals collectively who invented or discovered the subject matter of the invention. And there are many places in US law, in the patent statute, that make it clear that an inventor must be a natural person. Moreover, the courts have made clear that to be an inventor with respect to patent law, to be an inventor who may be entitled to a patent on your invention, that the person has to contribute to the conception of the invention. And so one of the questions that the PTO posed to stakeholders is, what about inventions where an entity other than a natural person, so where some AI system contributes to the conception of the invention? How might that affect inventorship in the US? And there were different responses to this, but for the most part, the consensus appears to be that this isn't really an issue yet, at least at this point. So first of all, some believe that the conception and the idea of conception, which is required to be an inventor under US law, is innately human. So that AI systems, at least right now, don't have the ability to conceive of an invention or participate in the conception of an invention. That's something that's innately human. On the flip side, it's fine if an inventor, a human, a natural person, uses an AI tool to develop an invention, right? That doesn't somehow undermine the claim to inventorship. So you can use an AI tool to aid your invention. As long as you conceived of the invention, that's fine. And then again, as I mentioned previously, there is a belief that this question of inventorship may need to be revisited in the future if and when machines begin achieving artificial general intelligence, meaning the AI system itself, right, can conceive in a way that a human does, or can start thinking like a human. Then we may need to revisit the question of inventorship. And at least some stakeholders have taken the position that if and when that ever happens, then while the AI system can't be an inventor, whoever the natural person is who owns or controls that AI system should be considered the inventor and should control the patent rights. So, but again, right now, there wasn't a call for sort of a need to change US law on inventorship. In copyright, it's very similar issues and sort of a similar consensus. So US law protects works of authorship, which means the work has to be created by a natural person. This is in line with, from an international perspective, is in line with the Berne Convention, which is interpreted authorship to require protection only for works that are created with human involvement. But again, works created by a natural person with the assistance of AI are protected. And this is nothing new, right? And that's, this has been true with technological developments throughout time. So for example, at the end of the 1800s, the Supreme Court decided that photographs could be protected by copyright law. Even though, right, the camera, right, the technological development arguably created the work, the Supreme Court held that as long as the photographer contributed creative elements to that work, for example, posing the subjects or making decisions about lighting or setting, then the photographer could be the creator and the author of that work, even though he was assisted by a camera, right? Similarly here, works that are created by a natural person with the assistance of AI are currently protected, and the consensus is that that should continue. In terms of going forward, should we change the law with respect to, if we get to a point again where AI systems can create works that would be subject to copyright protection, should that AI system be considered an author under copyright law? Most people thought no, and many look to the purpose of US copyright law, which is to incentivize people to be creative, just like US patent law's purpose is to incentivize people to be innovative, right? Under the Constitution, that's the purpose of our patent and copyright laws. Here, it wouldn't necessarily incentivize if we were awarding copyrights to AI systems, it wouldn't incentivize creativity. But again, some stakeholders believe that if AI does ultimately, at the end of the day, create a copyrighted work, then that work should be, the copyright to that work would be owned and controlled by the natural person who controls the AI system. Okay, so what about, several of the questions that were asked were whether our current regimes are adequate to protect AI. Current regimes under US law. And a majority or a lot of the stakeholders actually felt like right now we don't need any change to US law, that our current regimes are adequate. So what are the current regimes? Well, of course, patents, trade secrets, copyrights, and then state law, which is sort of a gap filler in IP in the US. So there are, as I just was talking about, many types of AI systems that can be protected under patent law. Trade secrets can be used in some circumstances. Copyright to at least the data, as I'll talk about in a moment. Sometimes copyright it can be used to protect the data that underlies AI systems. So copyright can't protect the data itself, but it can protect the way that data is organized and selected and arranged. So there is some protection from copyright law. And then state laws like contract laws and torts, like misappropriation, can sort of be a gap filler too. But even those who thought we didn't need, an overhaul of the current IP regimes believe that we do need more expertise and training. For example, for patent examiners working on AI applications, and many cited the Japanese and Korean patent offices, which have specially trained examiners in those areas. And many believe in the US we need the same thing. And that ultimately we may have to rethink our willful and intent requirements in IP law. If you intentionally infringe a patent or intentionally infringe a copyright, you're entitled to increased damages in the US, and that gets a little bit complicated if you're talking about an AI system. How can an AI system act intentionally? So that's something that somewhere down the line we may need to rethink. That said, there are some stakeholders in the US who think that databases that underlie AI systems do need action than currently get in the US, and have looked to the sui generis database protection law in Europe and have called for something similar. Of course, that was considered in the US about, I don't know, 10 or 15 years ago and was rejected, but some still think we need something to protect the underlying data because of all the effort and work and resources that go into collecting that data for AI systems. And then another issue that was raised and has been discussed is some sort of protection for ingested copyrighted works. So copyrighted works that are often used to create AI databases that are scanned and used. Many believe that the authors of those copyrighted works, that number one, that's copyright infringement, or at least it may be copyright infringement if it's not fair use, and that the authors of those copyrighted works should get some sort of compensation, and have suggested sort of a collective society and blanket licensing like we used for music in the US. So something that allows authors whose works are used and collected to create AI systems to get some sort of royalty, some sort of remuneration for their works being used in AI systems. And then the other topic is, what about the use of AI by the government itself? So just last week, the administration issued an executive order on promoting the use of trustworthy AI in the federal government. The executive order essentially says that the federal government is committed to accelerating the federal adoption of AI, to modernize our government, to make things more efficient, and hopefully to cultivate trust in the public with the use of AI. At the same time, the executive order recognizes that agencies have to protect privacy, civil rights, civil liberties, and American values. And so, of course, that's the tension with AI, with the collection of personal information and other data that's used in these AI systems. So just as an example, in the IP context, many agreed that AI software could be really useful to improve the PTO's ability to conduct trademark searches, to figure out if a trademark that someone is attempting to register is likely to cause confusion with other marks, and that most agree this could make the process a lot more efficient, but of course wouldn't necessarily supplant human trademark examiners, that we still need humans to be involved in the analysis of whether a trademark is so similar to another mark that it's likely to cause confusion, which is the test for trademark infringement in the US. So, but that's just one example of how governmental agencies can use AI. Okay, and then finally, I know I'm running out of time here, so I just wanted to mention some ethical considerations regarding AI. And this is something that was briefly mentioned in the PTO's report, but really I want to mention this because I think it's an issue that where we have a big hole in the US, where there's not enough focus or consideration given to these potential ethical problems. So many stakeholders have raised ethical concerns about AI systems, that they're biased and discriminatory, for example. And there've been, various examples. I think it was Amazon at one point was using an AI system to hire people that was favoring certain words in resumes, like executive, I think, and those were words that were generally used by men and not women, and so it was sort of biased against women, and so Amazon abandoned that system. There's also this concern with deep fakes, where these are generally videos that it's synthetic media, like videos that are used and created with AI technology that can manipulate images and trick people into thinking that they're listening to a message or seeing a video of someone who's not really saying those things. It's not really that person, and other dangerous products. There are a lot of ethical issues that are that surround the question of artificial intelligence. And in the US, the PTO and the US Court of Appeals for the Federal Circuit, which is the patent court in the US, have made very clear that they do not police or consider ethical concerns in granting patents. They used to in years past under a doctrine called moral utility. They used to reject patents on things like gambling devices as immoral, but for various reasons, the PTO and the Federal Circuit determined that it's not the job of the PTO, it's the job of other consumer protection agencies like the FTC. And so there's a question about what agency will take the lead on this with respect to AI, especially when it can be very difficult with respect to AI inventions to know exactly what what goes into that system. And that might be difficult for some agencies to determine sort of after the fact, as the FTC or other consumer protection agencies would do. And so, is it an agency? Is it courts? I'm not sure, but I think that's a big question for U.S. Artificial intelligence and IP policy that we'll have to face in the near future. Leah, you're still muted.
Okay, thank you, Megan, for pointing that out. I'm always afraid my computer's going to bing onto. So we'll now turn to Tytus, who will make a comment and then lead off the question.
Sure. So I'm starting at 10:35 here. Okay, so I thank you, Leah and Megan, for the warm introduction and the presentation. So my view is a view from the Bay Area, widzenie z nad Zatoki San Francisco. It's a view of a generalist and of a transactional lawyer. So I try to focus on, some practical things and also give you some background. So first of all, the USPTO report is the US government feeling out the ecosystem and trying to figure out how to respond. There is a general belief on the side of the US government that the IP system might not be adequate to protecting inventors and copyright ownership and offers in general. However, if you look at the report, there is not significant interest from the parties involved. There were a total of 99 responses, and out of the 99 responses, 2 were from law firms and 14 from practitioners. And most important, FANG has not responded. And what is FANG? FANG is Facebook, Amazon, Netflix, and Google. So there's no official response from the people who are pushing the frontiers of artificial intelligence. So that's sort of, important. So very limited response from people who are in the AI business to respond to IP ownership. Second, let's zoom out a bit for our friends in Poland. Copyright is not a side peripheral issue for the Anglo-American legal system. It's crucial, and it's as crucial that it's covered by the US Constitution. So basically, the founding fathers decided that authors, inventors have exclusive rights, and it's the responsibility of the government to protect these rights. The other thing that is unique for the Anglo-Saxon world and our legal system here is we had the first copyright act in the world in 1710. And the basic concept of copyright hasn't really changed since 1710. So this is the legal system that Megan and I are operating from. And now let's confront this with the Bay Area and the mecca of artificial intelligence. So first of all, this is a place that has a very fluid concept of what is human. Where does humanity begin, and what constitutes a human being? And that goes into gender fluidity. So the concept of humanity, which is required by the Copyright Act, is not written in stone from the perspective of the Bay Area. 2, this is a very unique place where non-competes and non-solicits are generally unenforceable. And then the business community as itself, number one, has a general disregard for copyright and IP protection, and is constantly revisiting the concept of IP and the need for IP protection. And there's a general trend that IP ownership is so passé, and it's only for fuzzy-dovey professors or lawyers.
I'm going to say quick, Megan, if you could just take your screen share off, that'd be great. Thanks. Sorry, go ahead.
Sure. So that's the Bay Area where AI is mostly created. So business community disregards copyright, revisits IP. A concept of humanity is fluid, and there's just a general feeling for experimentation. So now let's talk about the real world. I mentioned that there were very few comments from businesses in the legal profession from the Bay Area. There's also, I did a PACER search. PACER is the US litigation database that's run by the government, and there's literally 0 cases that involve AI and artificial intelligence. I also reached out, preparing for our panel, to key experts and special witnesses that are usually approached in IP AI litigation, and they also don't have they didn't have any information for me saying that, oh, we're currently involved in litigation and we're retained as experts. So basically, it seems the government is preparing itself, but the real world is not there yet, or is not there, or there's not enough cases to change the law here in the US. However, as Megan said, it's an interesting topic, and it challenges the concept of IP. And one of the key areas is the gray area of the creative process and what amount of human involvement is required for full copyright or copyright that is used by AI. And we use the term AI a lot. It's not clear what it is, but basically, AI is just pen and paper that was taught to do certain things that are uniquely, innately human. So, for example, collect, compile, and make decisions. So there are artificial intelligence. There's no fully artificial intelligence out there, but there are systems that are currently produced to automate, compile, and make life easier, and for human beings. Most likely, if there's going to be a dispute, practitioners will use Section 107 of the Copyright Act, which deals with compilations, to use that as the basis of trying to create basis for copyright. The other hot topic is who owns IP, and corollary of that is for how long is the protection period of copyright, for example. What will the future look like? No one knows. So that means it's very free to be invented. However, what do we know about the future and how the future of AI and copyright or intellectual property is going to be created? It's most likely not going to be created in Washington, D.C. With an amendment to the Digital Millennial Copyright Act, but it's going to be a case that comes from the California Northern District, so the Ninth Circuit here. The parties are going to be either Stanford University and FANG, so Facebook, Amazon, Netflix, or Google. So that's 100% sure, because these entities are going to fight for their ownership of intellectual property. And just to finish off, I think I want to mention one company that has a Central and Eastern European connection, and they're connected to me. They're called UiPath. They create something that's called robotic process automation. So basically, they get hired by Deloitte, Accenture, and they create a plugin that goes into the computer and follows the work of a secretary, a bookkeeper, And basically based on that, they create an RPA, a robotic process automation. And that AI, for lack of a better word, will create intellectual property based on listening and following to what people at Accenture, Deloitte does, and creates its own IP, and that artificial intelligence is reused by UiPath and Accenture, for example. If there was a sleepy lawyer not looking at the contract between UiPath and Accenture, that IP would not be assigned to either UiPath or Accenture, and there would be an issue of who owns the IP generated by the artificial intelligence. However, in practice, these are highly negotiated contracts where the IP clauses are pretty standard, and the IP generated by the artificial intelligence is directly assigned to either the vendor or the customer. So that's, big picture. 1 minute over. My question to Megan, Tadam, is let's talk about, innately human and what is the conception of concept of conception and what needs to be done by AI owners to create ownership in the copyright. So level of intervention and how direct does it have to be? Do we need to direct, instruct, or train the AI, and what levels? At what levels would that be? Thank you so much.
Sure. Thank you very much for your comments, Tytus. So I think in the copyright realm, the example of a photograph is a good one, right? That there has to be some human involvement, right? But as the Supreme Court said then, just because some photographers can become copyright owners because of the creative elements that they contributed to the work, that doesn't mean all photographs are subject to copyright protection. So unfortunately, I think right now, this is going to be decided on a case-by-case basis, right? And so, and that's sort of how copyright law is generally, right? The other way that some of these issues are being dealt with, of course, is through the fair use doctrine. The fair use doctrine is a defense, for those of you who don't know, in copyright law, where it's a defense to infringement, and the court will consider, the purpose and character of the defendant's use of the copyrighted work, how much of the work was used, whether the defendant's use transplants the original work, etc. And this is very fact intensive and is decided on a case-by-case basis. And it's the same for creative, whether someone is an author for copyright purposes. I think right now in the US, the standard is pretty low, right? For copyright ownership, right? It's not the sort of creativity that has to be demonstrated is nowhere near, for example, to the novelty requirement in patent law, right? In the US, in order to get a patent, you have to show your invention is new as compared to the prior art, right? With copyright law, the standard is not nearly as high. So it's a relatively low bar, but there will have to be some human intervention. And, I think right now, where our AI technology is, I think most AI works would meet that bar because they require some human intervention, right? But 5 years from now, 10 years from now, 20 years from now, that may not be the case. And so then I think your point about private ordering and contract law is going to be very, very important, right, in trying to determine who's actually the author and creator. And that's not foreign to copyright law, because of course, one place where US copyright law does recognize that a copyright belongs to someone who didn't actually create it is with respect to works for hire, right? So there is a model in that sense for this in the future.
How do you feel about, I'm, in my opinion, 99 comments to a USPTO document is not a lot. And, when I read it, I was like, oh, this is interesting. And then I looked at the footnotes and, Facebook hasn't commented, Google hasn't commented. It just seems to be like, were they on a coffee break or they're hiring or they're focusing on lobbying Congress for other things?
So I agree, it's not a lot of comments, especially because I recently was looking at comments to the FDA to the FDA with respect to, I have a child with food allergies, and there was a request for comments about adding sesame as a major food allergen, which, by the way, the Senate just passed a law on that today. So that's very exciting in my house. But there were thousands and thousands and thousands of comments about whether sesame should be added as a major food allergen in the US. And so I felt the same way. It's not a lot of comments. Do I think Fang was on a coffee break? No, I think it's intentional. I'm sure they were aware of that call for comments and made a deliberate decision not to participate. There were some big players like IBM, right, who did participate. IBM is a very important player in AI, and they did comment. But I think it's probably because we don't need to comment yet. I feel like felt like they don't need to comment yet. That maybe right now, the consensus seems to be the legal regimes are working okay. That may change, in the not too distant future.
Great. Well, you've gotten us off to a great start here. And we have a number of interesting comments in the questions in the chat. We have about 8 more minutes of the recorded portion. And then, as you know, we'll stop the recorded portion, and Megan and Tytus have agreed to stay on for half an hour, and I'll keep working my way through the questions and the new ones. I'm actually going to start with the question from George Garvey, who was actually the founder of the American Law Program and the LL.M program. So we're very honored that he's with us. I'm going to take his question first, though, partly because it's a definitional question about the domain of what we're talking about. He says, does the intellectual component of artificial intelligence consist mainly of algorithms?
Go ahead, Tytus.
George, thanks for the comment. That's the majority of it, but it also involves your input. So for example, Apple released Facemojis, and basically the Facemoji doesn't work without your input. And that opens the question, if you create a Facemoji recording, who owns that recording? Is it Apple based on its terms of service, or is it you?
Yeah, so I would just add that, algorithms are part of it. Of course, under patent law, algorithms are not protectable in the US. That's not patentable subject matter. We have certain exceptions to what can be protected, but they may be protected by some other IP regime like trade secrets or some other protection. But more importantly, it's not just the algorithm itself, but the process, right? So whatever the process is that uses that algorithm, that can be protected under a patent. The product of that AI process, that could be protected, either as a patented invention or as a copyrighted work. So the algorithm is part of it, but is only one aspect of what we're talking about here.
Okay, we have a question from Mateusz Bednarski, which is probably will be our final question in the recorded part, and then we'll switch and have time to do more. So he says, Inception of AGI would mean that, and this is in the chat, would mean that there now exists some other entities than human that are capable of complex, creative, and inventive work. Why try to discuss everything under the umbrella of AI and what type of AI constitutes inventive work, while 90%, if not all of AI is just ML. I hope you know what ML, machine learning.
Machine learning, yeah.
Okay, I got it. Which basically are nothing more than statistically tuned algorithms, and not try to discuss what actually constitutes intelligence, consciousness that gives us rights over animals, and go on with IP laws from there.
I would say, from the perspective of Crazy Bay Area, what are rights in animals have rights too. And, this is, the perspective of a place that's very futuristic and anything goes. So I agree with Mateusz that, you can have that, try to solve that problem from that perspective.
Megan?
Okay, sure. I guess I would say, if I'm understanding the question, I was trying to reread the question to make sure I'm understanding the question, which is, I would say, first of all, from a patent perspective, this is a question that I didn't get into here, but a question of, what is patentable subject matter in the US has been a matter of hot debate for the past 10 or 15 years, right? And a lot of that is because many of these inventions are just, software implemented inventions. And that's what we're talking about with AI in many instances too. And so, this is an area where, sorry, I don't know what's going on with the screen right now.
Just a little blip. It's okay.
Okay, so that's an area where there's been a lot of debate, certainly in the US. The Supreme Court has stepped in, and the pendulum has swung. Many think too far, right, in the wrong direction. That we used to we were issuing far too many patents and on anything and everything, and this was, led to this huge number of invalid patents in the US that created all sorts of problems. And so we passed major patent reform in the US in 2011, the America Invents Act, that and the Supreme Court decided several patentable subject matter cases that made it more difficult to patent many of these sort of computer implemented inventions or software inventions. And then, especially with sort of the rise of AI, a lot of stakeholders said, wait, we've gone too far in the US, and now you can things in China that you can't even patent in the US anymore. And so under the current administration, the PTO has sort of taken the lead on trying to tighten the reins a little bit and tighten the reins, meaning on the sort of restrictions on 101 and patentable subject matter, and allow more things to be patented. So, but as a general matter in the US with respect to patents, we don't distinguish between types of inventions. And so AI inventions should be treated like any other inventions. We don't patent differently based on type of invention.
Great, thanks. Thanks. As we're closing out this part, actually, Mateusz made a later comment, which is probably an ironic comment, that this all seems very human-centric, which I think is in line with Tytus's comment about the Bay Area's view of the world. So we're now going to again transition. We're going to shut off the recording, and this portion that you've heard thus far will be available on YouTube for you to see. But we're